Good morning, Bill Bernard at WFB Legal Consulting Incorporated. Today, I wanted to give you some quick 5 or 6 rules that you need to know for asset protection. Some basic things that you need to understand and incorporate into your toolbox. So as you move along in your asset protection and even your estate protection planning, you'll be aware of these differences. The first and foremost one is, of course, never begin your asset protection program once a claim has arisen against you or if you know one is on the horizon. Start early. Do it over a period of time. Make sure your transfers are in place. Make sure they're correct. Get a lawyer to do it for you and avoid what is typically referred to as a fraudulent transfer. If you do this, if you transfer your assets and try to hide them after a claim has arisen, the Uniform Fraudulent Transfer Act can take effect, and someone can attempt to prove by way of that act that this was a fraudulent transfer. Remember, whoever helped you transfer these assets, as well as yourself, could be liable for the creditor's attorney's fees if they have to prosecute such an action. The other thing is that it's not a substitute. Asset protection, it is not a substitute for insurance. Remember that asset protection, and we can take the most basic of examples where you have an LLC or an S corporation, that type of asset protection is going to protect your personal assets, your car, your home, your bank accounts, that sort of thing. Liability insurance, with the exception of the deductible that you might have to pay for having a policy, is going to protect your business assets, whatever your business owns. So one supplements the other. Don't think that because you have liability insurance, you don't need a business entity, or if you have a business entity, you don't need liability insurance. They both supplement each other and do different jobs. The other thing I want to bring to your attention is that personal assets are for trusts, business assets are for business entities. Going back to the LLC S Corp example, you protect your personal assets by having a business entity, but you transfer your personal assets by way of a living trust, okay? So a living trust is not to be used as a substitute for a business entity. Don't think that because your personal assets are in your living trust that they're going to be protected from a lawsuit. They won't be. They're in that trust to do a couple of things. One is to provide you with complete privacy in terms of whatever your estate consists of, and number two, allows it to pass by way of the trust instead of going through probate court, and of course it avoids the great expense of probate as well as the length of time that probate takes. So keep those points in mind. They're very, very critical. And lastly, I want to mention offshore accounts. Don't think that because you have your money in offshore accounts, you're safe. The federal government can issue what's called courts can issue what's called a repatriation order, keeping you in jail for contempt of court until you decide you're going to turn those assets over in payment of a creditor situation. They can't make you do that, but they certainly can hold you in jail for contempt. Moreover, the IRS has instituted a number of different programs with offshore governments now where they will make trading and a number of other things very difficult for those other countries if they don't cooperate in making sure that your assets are accessible should a judgment be rendered against you. And remember, going back to point number 1, if you make a fraudulent transfer and it's determined it is fraudulent, you're not going to have any luck in bankruptcy court either, because bankruptcy court will not uphold any type of fraud. So again, I hope that helps. I hope that puts things in perspective for you. Remember those 5 or 6 rules and start your asset protection plan early. Thanks very much. See you again soon.